UN Secretary General, Your Excellency Macky Sall, the former President of the Republic of Senegal, all Cabinet Secretaries present, all Principal Secretaries present, the Chief of Defense Forces, honored guests, distinguished ladies and gentlemen, good morning. Your Excellency, this state investiture ceremony is convened pursuant to Article 132(4)(c) of the Constitution to confer national honors upon distinguished individuals in service to the people and the Republic of Kenya. This constitutional tradition has been operationalized under the National Honors Act, Chapter 216A of the Laws of Kenya, grants the President the prerogative to confer national honors in recognition of individuals whose everlasting example of distinguished service to the nation, the region, and to the totality of humanity. The formal conferment of the honor is notified through a day of July in the year of our Lord 2025. July in the year of our Lord 2025. In the discharge of your constitutional duty, Your Excellency has conferred a national honor upon His Excellency Ban Ki-moon, a statesman of an impeached distinction as the 8th Secretary General of the United Nations from 2007 to 2016. Your Excellency, over his 2 terms, His Excellency Ban Ki-moon rallied the world community to confront our most urgent challenges: climate change, armed conflict, humanitarian crisis, gender inequality, and the pursuit of sustainable development, transforming multilateral cooperation and leaving a legacy of strengthened institutions and bold initiatives. In championing for climate action, His Excellency Ban Ki-moon was the first UN chief to attend every session of the UN Framework Convention on Climate Change, personally shepherding diplomatic efforts through COP15 and on to COP21 in Paris, where the landmark Paris Agreement was adopted by consensus on 12th December 2015, a resounding triumph not only for our Earth but for multilateralism as well. Your Excellency, during his tenure at the Global Center, he launched the African Adaptation Acceleration Program in close collaboration with Your Excellency President William Ruto, His Excellency President Macky Sall, and other African leaders, shaping billions of climate-resilient investments across the continent. To date, the Triple AAP has helped shape $1 billion in resilient development finance in Kenya alone. And with the groundbreaking of our new GCA headquarters in Nairobi today, we reaffirm our commitment to equal partnership between the Global North and the Global South. Your Excellency, to facilitate the conferment and keeping with the constitutional tradition for state investiture of honors, permit me now to invite the Chief of Defense Forces to take his place at the conferment arena. Your Excellency, sir, it is now my distinguished honor and high privilege to invite you, sir, to take your place at the conferment arena.
His Excellency Ban Ki-moon, before taking up the UN Secretary General role, was the Minister of Foreign Affairs and Trade of the Republic of Korea. His responsibilities during the 37 years of his ministry included foreign policy and advisor to the President, Chief of National Security and advisor to the President. His Excellency Ban Ki-moon was the 8th Secretary General of the United Nations. He served 2 consecutive terms from 2007 to 2016. Throughout his tenure at the UN, His Excellency Ban strove to be a bridge builder, to give voice to the world's poorest and the most vulnerable people, and to make the organization more transparent and effective. He successfully pressed for action to combat climate change, an effort that culminated in the adoption of the rapid entry into the landmark Paris Agreement in 2016. His Excellency Ban Ki-moon worked closely with members of state of the UN to shape the 2030 Agenda for Sustainable Development and to establish the UN Women Which Advise Organization to work for the gender equality and women empowerment. His Excellency Ban has also launched major efforts to strengthen UN peace operations, to protect human rights, to improve humanitarian response, to prevent violent extremism, and to revitalize the disarmament agenda. He currently serves as the chairman of the Ban Ki-moon Foundation for a Better Future, president of the Assembly, and chair of the Council of the Global Green Foundation Institute, an organization Kenya enjoys membership and has its position itself to host for the region. His Excellency Ban Ki-moon is in Kenya for the groundbreaking of the Global Center for Adaptation, which he serves as an honorary chair of the Supervisory Board. He is married with 3 children and 4 grandchildren.
Your Excellency, sir, I now invite His Excellency Ban Ki-moon to come forward and take his place at the conferment arena. Sir, you will confer and bestow highest national honors award of Chief of the Order of the Golden Heart of Kenya, CGH, on behalf of the people of Kenya. Your Excellency, sir, as we culminate the day's ceremony, I invite you, sir, to take your seat on the ceremonial desk to execute the Presidential Award Certificate. The awardee will witness as Your Excellency sets your hand. As Your Excellency sets your hand onto the certificate. Sir, permit me now to invite the State House Legal Counsel to convey the instruments. Your Excellency, sir, you may now kindly hand over one copy of the instrument to His Excellency Ban Ki-moon, CGH. Your Excellency, sir, may I now invite you, along with His Excellency Ban Ki-moon, to graciously retreat the arena for the rest of the program. Sir, permit me now to invite the State Awardee, His Excellency Ban Ki-moon, CGH, to make his acceptance remarks.
Your Excellency, President William S. Ruto, President of Republic of Kenya, Excellencies, Ambassadors of Diplomatic Corps, Minister of the Government, and also, in particular, Ambassador Amy Jerono Kipsoi of Kenya to the Republic of Korea, and also Ambassador Kang Hyung-sik of Republic of Korea to Kenya. And distinguished guests, ladies and gentlemen, good morning. I'm truly honored to be here with you today. I thank you from the bottom of my heart for this honor, the Order of the Golden Heart of Kenya. It is a truly humbling moment for me to accept this award, Mr. President. I feel such a strong kinship with Kenya and the people of Kenya. You have meant so much to me, both in my professional and personal life. And during my 2 terms, 10-year service as the 8th Secretary General of the United Nations, I visited Kenya more than any other African countries. Kenya's capital is home to thousands of United Nations workers for whom I was responsible. I can tell you that during my term of office, I only heard good news from my staff about the hospitality and generosity of spirit of Kenyans. I also have very special family reasons to be grateful to the people of Kenya. It was here in Nairobi that my beloved daughter, Hyun-hee Ban, met her husband, Sid Chatterjee, who are now working as at UN Resident Coordinator in Beijing, China, together, after many years' service in Kenya. I well recall making a secret visit to Nairobi when I was Foreign Minister to celebrate the wedding ceremony of them here in Kenya. I took personal leave and disappeared for a few days. And what memories I still carry with me of that joyous occasion. My grandson, Jay, also spent his earliest years very happily here in Nairobi. So, you can see, with 3 generations of my family connected to Kenya, I am particularly a Kenyan myself. Thank you very much for this honor. Kenya has always been a great friend of my country and also of my mind. And I have one more secret reason to feel the deepest gratitude to you, Mr. President. After I stepped down from the United Nations as Secretary General and returned home, the first place I headed was Kenya. After a couple of weeks of relaxation and reflection, I felt rejuvenated by this great nation and was able to start on the next stage of my life and career. Kenya came to my rescue in a moment of need and served up a tonic that has helped propel me forward ever since. Excellencies, distinguished guests, finally, to close the circle, during September 2023, I was in Nairobi to participate in the Africa Climate Summit in my capacity as chairman of the Global Center on Adaptation. I was pleased that during the summit, His Excellency President Ruto kindly agreed to join the board of Global Center on Adaptation. It was a win for the cause of adaptation to climate change because the world needs great African leadership on the climate emergency. Thank you, Mr. President. And it is a win for Kenya because it cements this great country's role in the vanguard of global effort to adapt to many adverse consequences of rising temperatures, while at the same time creating thousands of new green jobs, not just here in Kenya, but right across the mightiest continent of Africa. And now here, we are to celebrate the groundbreaking of the all-new headquarters of the Global Center on Adaptation, which thrusts Nairobi to the center of global and regional activity on climate adaptation for the future. It is indeed also a landmark development. Global Center on Adaptation, GCA, will be the first ever global organization headquartered equally in the global north, in Rotterdam, the Netherlands, and in the global south, here in Nairobi. This dual headquarters symbolizes exactly how the world needs to conduct business today. This century is Africa's century. Without addressing the challenges of Africa, which they are now facing, I've been repeatedly saying that in my capacity as Secretary General, and even after that, we will never be able to declare that we are living in a sustainable world. That's the message which I've been carrying out even this morning. And let us work together. This century is Africa's century. But Africa will only secure its future if Africa can protect its development from climate shocks. And GCA Africa headquarters will be your launch pad for adapting Africa at speed and at scale. In marking this auspicious moment, I also would like to recognize, I cannot leave this place without recognizing the African leadership of President Macky Sall, former President Senegal. Thank you, Mr. President. He kindly accepted to take over my role on the GCA Supervisory Board as chairman. Thank you very much for your leadership. I continue to support this great organization as its honorary chairman of GCA. President Macky Sall's leadership on adaptation in Africa when serving as African Union chairman was remarkable. Thank you very much, Mr. President, again. Excellencies, ladies and gentlemen, Mr. President, I also want to take this opportunity to specifically highlight the lifelong contribution of my dear colleague and my friend, Professor Dr. Patrick Verkuyen, who is here with us. With my hand on my heart, I want to testify before all of distinguished guests this morning that in all my travels, in all my engagement, in every office I have ever held at the United Nations, in Korea and elsewhere, I have never come across any individual with such a drive and your commitment and your level of excellence and with passion and compassion. I have full confidence that both of you, President Macky Sall and Dr. Verkuyen, working together will deliver incredible results for climate adaptation for Africa and the world. I repeat, I have spent so many years in so many places as public official, but it's very hard to find such a dedicated person as Dr. Verkuyen. I know that Professor Verkuyen is the best set of hands that could be in place at the University of Nairobi, the premier tertiary institution of this nation, To all the Kenyans present here, I would like to say following. We are in a world of turbulent times across the globe, but appeal to all of you, all of us, young and old, north and south, east and west. We must work together. Let us work together. Let us seize the moment to create a world, new world, in which we all can thrive. Mr. President, that's now for your political responsibility. But for now, as a private citizen, is my private, individual, moral responsibility. When moral and political responsibility join together their hands, there is nothing which we cannot solve. That's my firm belief during my almost longer than 50 years of public service, including 10-year service at the United Nations. When both our political and moral responsibility work together, we will be able to declare that to our succeeding generations that we have done all to realize a better world for all our future generations. And I count on your leadership. Everybody sitting here, including His Excellency President. So, ladies and gentlemen, Excellencies, let us work together. That is what we are mandated to do. So that's why I'm here. That's why I'm honored. And that's why I'm really committed to work continuously alongside with you. Thank you very much for this honor, and I wish you all the best. Thank you very much. Asante sana.
Your Excellency, sir, it is now my distinct and high privilege to invite Your Excellency to convey your congratulations to the State Awardee.
Thank you very much. Please, let's take our seats. Your Excellency Ban Ki-moon, on behalf of the people and government of Kenya, I extend my very heartfelt congratulations to you upon your receiving our nation's highest honor, the Chief of the Order of the Golden Heart. This recognition is a testament to your global leadership, tireless advocacy, and unwavering commitment to a just, peaceful, and sustainable world. As the 8th Secretary General of the United Nations, you distinguish yourself as a bridge builder and a champion of the world's most vulnerable. Your visionary leadership placed climate change at the forefront of the global agenda, beginning with the 2007 Climate Change Summit, and through sustained diplomatic efforts that mobilized unprecedented international attention. Your legacy continues to inspire us as we confront the harsh realities of a changing climate here in Africa. Your tenure also brought transformative change to the United Nations. You strengthened the institution's capacity to address crises, from food and energy insecurity to pandemics, while amplifying the voices of the poorest and the most marginalized. Your successful appeal for more resources during the global financial crisis steadfast helped yield millions from hardship, and your steadfast commitment to the Millennium Development Goals delivered tangible progress particularly for Africa. Equally remarkable is your lifelong advocacy for human rights and gender equality. The creation of the UN Women and the numerous initiatives you championed to end violence against women reflects your deep conviction that sustainable development must be inclusive and must be just. Later today, we break ground for the Global Center on Adaptation, the new headquarters in Nairobi. We are reminded of your enduring commitment to climate action. This center stands as a symbol of our shared resolve to build resilience and secure a sustainable future for the present and future generations. Kenya is proud to honor you for your lifetime of service to humanity. May this award serve as our profound appreciation of your vision, dedication, and lasting impact of your work on humanity. Your Excellency, you are also a great inspiration to me and the work that I have undertaken on behalf of the people of Kenya and on behalf of our continent has had great bearing to your inspiration as a world leader and as a man who has driven climate action to the center of world attention. Today, as we will be doing the ceremony of the new headquarters for global GCA, I also commend my brother, President Macky Sall, former president of Senegal, for his leadership in our continent as our former chair of the African, and promise him my support, the commitment of the government and people of Kenya as we work together towards managing the effects of climate change that are ravaging not just our continent, but the globe in equal measure. The setting up of the Global Center of Adaptation Dual Headquarters in Nairobi sends a powerful signal that matters climate are a dual concern of the global south as much as it is for the global north, and brings all our synergies together to solve this global challenge. And therefore, I am very proud this morning, Ban Ki-moon, as you receive the highest honor of the Republic of Kenya for your well-deserved service to humanity. You have our prayers as you continue to serve in your various other capacities. And as you have said yourself, this is your other home from Korea. You're always welcome to Kenya. You have a solid relationship with our country, and we are proud of that relationship. Thank you very much. May God bless you, and my very best wishes as you move into the future. Asanteni sana. God bless our nation.
Your Excellency, Dr. William Samoei Ruto, President and Commander-in-Chief of the Kenya Defense Forces, Your Excellency, Macky Sall, the Chair, Global Center for Adaptation and fourth President of the Republic of Senegal, Your Excellency Ban Ki-moon, CGH, 8th Secretary General of the United Nations, Your Excellency Yu Sun Taik, spouse to His Excellency Ban Ki-moon, Cabinet Secretaries Honorable Ruku and Dr. Deborah Mulongo, Your Excellency Ambassadors, the CEO, Center for Global Adaptation, Professor Patrick Vaikoyen, Principal Secretaries present, Kenya School of Government leadership present, stakeholders and partners present. Your Excellency, sir, with your permission,
Allow me to start us off on the speech section to invite the CEO Global Center for Adaptation, Professor Patrick Varkoyen, to make his remarks. Why don't we welcome him with a clap, kindly? His name is not an easy one, so he'll correct us if we're wrong. Welcome, sir.
Your Excellency, President William Ruto, Your Excellency, President Macky Sall, Your Excellency, Secretary General Ban Ki-moon, CSs, PSs, Excellencies. Mr. President, why are we here today? Wote ni wa Kenya. We're all Kenyans because in the climate crisis, all of us are in the same boat. But Mr. President, the irony is we also face an age of climate apartheid. We're the most vulnerable in the global south. Here in Africa, we suffer. Well, the most protected in the global north, where I'm from, we're shielded by wealth and infrastructure. In Kenya, in Africa, families trapped of drought, of flood, of loss, and of rebuilding again. Well, elsewhere, up north, protection is purchased. Early warning, insurance, the billions invested. Well, Mr. President, starting today with this groundbreaking, we can work together to put an end to this scenario. Because, Secretary General, as you said many times over the last 50 years, if we do not act boldly, at scale, now, we will all pay the price. Mr. President Ruto, as you reminded us, adaptation is not charity. It is simply smart economics. Jobs, trade, $1 trillion investment opportunity. And let's not forget, it is also a security agenda. And my country in the Netherlands, we convened the NATO summit 2 weeks ago. And NATO countries agreed to 5% of GDP on security matters. But what is very important, within that 5%, there is a 1.5% security-related expenditures. It is extremely important that adaptation for Africa will be conceptualized within that 1.5%. So, Mr. President, if I may, why is this groundbreaking today so important, perhaps even historic? You said it yourself, sir, this morning. This is the first ever dual headquarters of any international organization. Not number 5, not number 4, not number 3, the first ever, North and South, Rotterdam and Nairobi, equal. This is the future, ladies and gentlemen. This is justice. This is a movement. This is much more than just a building. So thank you, Mr. President, for making this moment possible. Thank you, Mr. President, for your vision. Indeed, sir, if I may disclose, it was you who called for this day when you visited our largest floating office in the world in Rotterdam. And it was and that is not much appreciated inside this country. What the President is doing outside this country for the people of Kenya. Because you told us in very blunt words, Mr. President, that in Africa, we're not beggars. In Africa, we're looking for equal partners. And that is not much appreciated inside this country. What the President is doing outside this country for the people of Kenya. Because you told us in very blunt words, Mr. President, that in Africa, we're not beggars. In Africa, we're looking for equal partners. because this is Africa's century after all. And here in Nairobi, we will build one of the most advanced nature-based offices in the world for Kenyans, with Kenyans. So thank you also, President Macky Sall. Your leadership, sir, as chair of our board, it drives this mission. Mr. President, it was you who put on the table, on the global stage, the largest adaptation program in the world for Africa, the Africa Adaptation Acceleration Program, and it is delivering because of you. Secretary General Ban Ki-moon, sir, you, sir, paved the way. And today's national highest honor, as we witnessed this morning, is so well earned. And quite frankly, it serves as an inspiration to all of us, as does your legacy. Finally, Mr. President Ruto, and also to the people of Kenya, young and old, this house is yours. Carry it, lift it, let it thrive. Why? Wote ni wa Kenya. We're all Kenyans. I thank you. Asante sana.
Another round of applause for Professor Patrick for his passionate speech. Your Excellency, allow me to also recognize the presence of Mrs. Zainab Hawa Bangura, the Undersecretary, Director General, United Nations Office at Nairobi. As I also call on the next speaker, at this point, allow me to invite the Cabinet Secretary, Ministry of Public Service, Human Capital Development, and Special Forums, Honorable Ruku, to make his remarks. Please, let's give him a hand of applause as he comes in. Welcome.
Thank you very much. Your Excellency, the President of the Republic of Kenya and the Commander-in-Chief of the Armed Forces or Defense Forces. Before I make my remarks, Your Excellency, allow me to invite my colleague, my sister, Cabinet Secretary for Forestry, Environment and Natural Resources, Dr. Barasa. Welcome.
Your Excellency, the President of the Republic of Kenya, Dr. William Samoei Ruto, Your Excellency Ban Ki-moon, 8th Secretary General of the United Nations and Honorary Chair of the Global Center on Adaptation, Your Excellency Macky Sall, 4th President of the Republic of Senegal and Supervisory Board Chair of the Global Center on Adaptation, Professor Patrick Vakoyen, the Chancellor of the University of Nairobi and President and CEO of the Global Center on Adaptation, distinguished guests, ladies and gentlemen, good afternoon. Let me begin by experiencing Kenya's profound gratitude for convening this landmark event, the groundbreaking ceremony for the Global Center on Adaptation, Africa headquarters here in Nairobi. This is a truly historic moment, one that marks a bold step forward for Kenya's leadership on climate action and for Africa's shared journey towards resilience. Excellencies, ladies and gentlemen, this milestone has been years in the making. Just last year, His Excellency the President William Ruto met with Professor Vakoyen, the CEO of Global Center on Adaptation, to set in motion an ambitious vision establishing this headquarters as a beacon of Africa's innovation. For Kenya, this headquarters reaffirms our place as a continental leader in climate action. The President's directive was clear: to create a world-class institution that embodies Kenya's commitment to adaptation and positions Nairobi as Africa's hub for sustainable solutions. For Africa, it represents a united front against climate vulnerability, a place where ideas become actions and plans deliver progress. And for the world, it stands as a powerful reminder adaptation is no longer optional. It is an urgent necessity that demands courageous leadership. Excellencies, ladies and gentlemen, Kenya has long been at the forefront of climate adaptation, championing solutions that address the urgent challenges posed by climate change. From the devastating droughts that have threatened our food security to the floods that have disrupted the economy and lives and livelihoods. The impacts of climate change are not abstract, they are our daily reality. Yet, in the face of these challenges, Kenya has emerged as a beacon of innovation and resilience. Our National Adaptation Plan is a testament to our determination to turn climate risks into opportunities. The establishment of the GCA Regional Office in Nairobi is aligned with this vision. It is a recognition of Kenya's role as a hub for climate action and a catalyst for transformative change across the continent. Today, we elevate this partnership to new heights. The GCA Africa headquarters will become a nerve center, knowledge sharing, policy innovation, and scalable solutions that Africa and the world urgently needs. We reaffirm our pledge to host not just a building, but a global epicenter for adaptation knowledge, finance, and leadership. Let us seize this moment with determination and optimism. The future is resilient, and it begins here in Nairobi. Excellencies, ladies and gentlemen, this remarkable achievement is a testament to the power of partnership between the Government of Kenya, the GCA, and visionary allies. And with its nature-inspired design, this headquarters will stand as a symbol of harmony between humanity and the environment, an inspiration to us all. I thank you very much.
Let's give a warm applause again. Your Excellency, the President of the Republic of Kenya and Commander-in-Chief of Kenyan Defense Forces, Dr. William Samoei Ruto, Your Excellency, the fourth President of the Republic of Senegal, and the Chair of Supervisory Board of Ruto Center on Adaptation, Mark Sall, Your Excellency, the eighth Secretary General of the United Nations and Honorary Chair of the Supervisory Board of Ruto Center on Adaptation, Ban Ki-moon, Cabinet Secretary for Environment, Climate Change, and Forestry, Dr. Deborah Barasa, all the Principal Secretaries present, Chief Executive Officer of Ruto Center on Adaptation, and University of Nairobi Chancellor, Professor Patrick, Board of Directors and Management of Kenya School of Government, led by Professor Nura Mohammed, and the Chairman, Retired Justice Charles Nyachae. Ladies and gentlemen, I'm Jambo. Mr. President, I am a little bit under weather. The weather has not been very kind, so my voice might be a bit different from usual. Your Excellency, I am honored and proudly privileged to stand before you on this historic groundbreaking ceremony of the Ruto Center on Adaptation Headquarters. I congratulate you, Your Excellency, sir, for taking the bold step towards implementation of the agreement that was reached at the COP28 Conference 2023. This agreement resolved that GCA Africa headquarters to be set in Nairobi, Kenya, as a hub for addressing climate change and promoting sustainable development in Africa. Your Excellency, before I make my remark on this historic moment, permit me, sir, to acknowledge and appreciate the team of public officers from the Ministry of Public Service, Human Capital Development and Special Programs, led by the Principal Secretary, Dr. Kere Ibunya, and also Mr. Ismail, and other Secretaries Bongo and the entire team. And also, I recognize and appreciate the Ministry of Foreign Affairs, also led by P.S. Ingoe, Ministry of Environment and Climate Change, Forestry, and all of them are here. Ministry of Land, Public Works, Housing, and Urban Development, Office of the Attorney General, and the Board of Directors and Director General of Kenya School of Government that work tirelessly to ensure the success of today's event. I remember, Your Excellency, your instructions were very clear to all of us. Most of these officers, public officers, were in the office on Saturday as well as on Sunday, through your very firm instruction, Your Excellency. I congratulate all these public officers for the work which they have done. I also want to thank and appreciate the participants of COP 2028 Conference 2023 and the Global Center on Adaptation for choosing Nairobi as the home of GCA Africa. This is a vote of confidence in Kenya's commitment to sustainable development, protection of environment, and the natural resources. Your Excellency, sir, Kenya has ratified the Convention on Biological Diversity, the Africa Convention on Conservation of Nature and Natural Resources, and the United Framework Convention on Climate Change. It has also adopted the Montreal Protocol that addresses ozone-depleting substances and the Kyoto Protocol that focuses on reduction of greenhouse gases emissions. Sustainable development is now a value and principle of national governance in Kenya under the Article 10(2)(d) of our Constitution. Clean and healthy environment and natural resources are also protected under the Article 42, Article 69, Article 70, Article 71, and 72 of our Constitution. Africa is vulnerable to climate change, and Kenya has demonstrated its readiness to lead in climate resilience initiatives. GCA Africa will be a valued partner in this. Your Excellency, sir, GCA Africa Headquarters project in Nairobi is yet another major milestone in Kenya's commitment to sustainable development, sustainable exploitation of resources, utilization, management, and conservation of the environment and natural resources. GCA Africa Headquarters project represents hope and humanity as it aims to champion climate adaptation in Africa by providing scientific insights and recommendations in key sectors such as food security, natural environment, water, cities, infrastructure, disaster risk management, and finance, and more so climate finance. So, Your Excellency, sir, today we not only lay a brick and mortar foundation of the landmark facility in Kenya, or groundbreaking, but also a foundation of dedicated action and collaboration on climate adaptation across Africa continent. Your Excellency, at a personal level, since the year 2009 up to the August 2022, when I was elected Member of Parliament, I worked in climate mitigation and adaptation projects across Southern Africa region. I was involved in climate resilience initiatives in Kenya, in South Africa, in Malawi, in Madagascar, in Namibia, in Mozambique, as well as in DRC. I therefore fully associate with the objectives of Global Center on Adaptation and the need for proposed GCA Africa Headquarters in Nairobi. It is therefore gratifying to witness the operationalization of the partnership between Global Center on Adaptation and Kenya School of Government and an institution that is under my ministerial responsibility. I thank you, Your Excellency, sir, for entrusting me with the charge of actualizing your resolve to operationalize the dream of COP 2028 conference in the year, COP 28 conference in the year 2023. Your Excellency, the physical benefit of because the project component include the GCA Africa Headquarters. That will house the GCA Africa team, the Masingira Uduma House, that will house the Ministry of Environment, and the residential feeders and department that will showcase and prioritize climate adaptive and ensure sustainability of the programs. I hope, Your Excellency, as I close, that African education curriculums will be enriched by and through activities of GCA, so as to provide the country and the continent with innovative and practical solutions to sustainable development, sustainable exploitation, utilization, management, and conservation of environment and the natural resources. With your permission, sir, my Ministry of Public Service, Human Capital Development and Special Program intend to enhance the mandate and the curriculum of the Kenya School of Government by introducing continuous professional development programs through which the school will sensitize all public officers on sustainable development and management and conservation of the environment and natural resources as part of the public service culture. Your Excellency, I congratulate you as we commence construction of the GCA Africa House, Masingira House, and other facilities which will be constructed here. And as you turn the vision of transforming Africa climate resilience into reality, I thank you, sir, and may GCA Africa Headquarters project serve as a symbol of Africa adaptation of sustainable development, sustainable exploitation, utilization, management, and conservation of environmental and natural resources. I thank you, sir, and may God bless you and all the actors who are making this a reality, from Professor Patrick to His Excellency the President Macky Sall, and also to His Excellency the President Ban Ki-moon. May God bless you all. And therefore, and with those remarks, Mr. President, it's my privilege and honor, and with your permission, sir, to welcome the fourth President of the Republic of Senegal, His Excellency Macky Sall, to come and address this congregation. Thank you, Your Excellency.
Thank you very much. Your Excellency, President William Samoei Ruto, President of the Republic of Kenya, and dear brother, Your Excellency, Secretary General Ban Ki-moon, and Madam Ban, Excellencies, Member of the Government, Madam Bangura from the UN, distinguished ladies and gentlemen. Mr. President, I'm a little bit sorry for my voice because I got cough here, because I found Nairobi with a very cold weather at this summertime in the North Hemisphere. So please accept my apologies for that. Let me begin by deeply thanking my dear brother, President William Ruto, and the people of Kenya for your friendship your hospitality, and for your leadership. President Ruto, your leadership on climate is clear. You have made Kenya a center for your efforts. It is also a privilege to stand with a global leader, His Excellency Ban Ki-moon. As Secretary General, your legacy speaks for itself. As the 8th Secretary General of the United Nations, you secured the Paris Agreement. Only this point is a big legacy for the humanity. So thank you, Secretary General Ban Ki-moon. Allow me also to recognize Professor Patrick Varkoyan, CEO of the Global Center on Adaptation. It is thanks to your determination that the GCA has grown into a force for real solutions. Your Excellencies, this is an important day for Africa, the absolute front line of the climate crisis. Yet, our groundbreaking marks a new era, one of renewed and equal partnership, North-South and South-North. Our new dual headquarters on the Global Center on Adaptation, I'm proud to serve as the chair of the board. And to be here with you today as we break ground for this unique new dual headquarters, as you said. Nairobi, Mr. President, is the perfect place for this office. It is dynamic, well-connected, forward-looking, one of the leading global centers for the planet. And congratulations. Adaptation is not secondary. It is a lifeline. Without adaptation, we know there can be no sustainable development. I'm proud that the GCA will anchor its work here in Nairobi, and especially proud that the AAAP, Africa's flagship program, will now be positioned to grow stronger from this very place. And Mr. President, we count on you to be our best ambassador and envoy on the name of Africa and the name of all the Global South to develop this AAA 2.0. This is not just an office, it is a platform for African voices and African solutions, home ground. The GCA looks forward to working hand in hand with Kenya, with Africa, and with the world. Together, we can build a more
to that of, please come and make your statement.
Your Excellency, GCA Macky Sall and our dear Macky Sall and our dear and all this whole manager of this GCA, Verkuyen, and the ministers, ambassadors, ladies and gentlemen. I was not scheduled to speak, so let me just say briefly how I appreciate the leadership and commitment and his own carrying on, working together with the world leaders to make sure that our humanity and our global earth will remain safe and sound. It's not only for retirement from the United Nations. It's almost approaching 9th year now. Many people ask me, what did you do during your 10-year service as a Secretary General? What are you proud of? I clearly said that I did my best effort to bring all the leaders of the world, political leaders, business leaders, civil society leaders, to join their hands on the deck together to address the rapidly approaching climate change issues. This is what scientists have confirmed, 120%. For me to make sure that my voice becomes stronger and convincing to other people, I should have known what is really happening. I'm not a scientist. I'm just a political scientist, and I'm not an economist. I didn't know much about climate issues. That's why I really wanted to lead by example so that I would be able to convince the people so that what I believe must be convinced by other people around us who are not convinced if and whether this climate phenomena was approaching. I visited 5 times Arctic areas. First, Antarctica, 4 times Arctic area, risking my own safety as a Secretary General. I standing on the melting ice. I've been speaking out to the people of the world. The global glass has to small island developing states in the South Pacific, Caribbean Sea, so you name it. That's why I was able to lead this campaign. I have been speaking out to, first of all, convince President Bush of the United States. He was not much convinced. Just like, it's quite strange, just like the current President of the United States is not convinced. This is very sad. This is a crisis. This is a global crisis, starting from top and most powerful country. Of course, I'm not here to complain about this. He withdrew from Paris Climate Change Agreement twice, during his first term and after that, second term. This is not acceptable. In the name of humanity, in the name of global citizens, I think we must speak out. This is what I believe, and this is what many scientists, now small children in the elementary school, they now understand. They are now speaking out. Young generations are speaking out. Women are speaking out. I've been speaking out that addressing this current crisis, like climate change or sustainable development goals, cannot be done by any single country. Any single country, however powerful, however resourceful one may be, cannot do it alone. United States cannot do it alone. European Union, they are the most well-to-do, well-organized countries. United Nations, European Union cannot do it. In such a case, then Africans, of course, Africans are the most hit, most severely hit without addressing anything. So you hold this amount of greenhouse gas emissions emitted by 54 African countries, less than just 5%, while China, 24%, while United States, 15%. United States, China combined, two countries produce almost 40% of global emission. Does it make sense? Are they really doing what they should do? I believe that China fully understood they are doing. We have to urge the United States, speak up, that U.S. must join. I'm sure that whoever may be elected president next time, they will join. But even a single moment, 10 minutes, 1 hour, is precious to us. It's only African countries who will suffer the most, who has contributed the least. It's unfair. Those people, those countries, 54 countries, who have least almost nothing for current. But Mr. President, you cannot do it alone. However, you are the president, powerful. Hold your people. Ministers, not to mention, must work together. But ladies and gentlemen, I have only moral responsibility. But those you are sitting here, I have only moral responsibility. But those you are sitting here, Morsi, you have political responsibility. President Ruto, you have 100% political responsibility. Please work your comrade, now presidents, prime ministers, and ministers of Africa. When Africans are united, there will come support from other regions. I'm sure that U.S. will join us soon. It's a matter of time. Asians, Chinese, Koreans, all will be there. So ladies and gentlemen, let us work together, joining your hands on the deck, that one day your great children should be proud that my grandfather, my grandmother did all what they should do. This is what your strong commitment. That's why I am here as a private citizen, now as honorary chairman of GCA. I will do my best. So I thank you very much, and let us praise President Ruto's leadership and also all of you to make sure that our world, people, and planet Earth, the only planet Earth we have found, will be safe. Thank you.
Thank you very much, Secretary General. Let's take our seats. I am not quite sure, Your Excellency Ban Ki-moon, that you were not prepared to speak. I think you have spoken better than even those who had wanted to speak. And thank you very much for your comments and the passion you demonstrate on matters climate change. Your Excellency Ban Ki-moon, 8th Secretary General of the United Nations and Honorary Chair of the Global Center on Adaptation. Professor Patrick Varcoyen, President and CEO of the Global Center on Adaptation. Distinguished guests, ladies and gentlemen, Kenya, like many African countries, is experiencing the harsh realities of climate change, as has been very ably spoken to by our former Secretary General. From prolonged rains, prolonged droughts, to devastating floods and unpredictable weather patterns, our communities and ecosystems are under to respond effectively. It is therefore my privilege and honor to join you this afternoon for the groundbreaking ceremony for establishing the Global Center on Adaptation Dual Headquarters here at the Kenya School of Government. This occasion symbolizes a new chapter in Africa's response to the escalating climate crisis. The establishment of this center is timely. It is also strategic and visionary. It will serve as a regional platform for policy dialogue, cutting-edge research, and capacity building to accelerate climate adaptation at all levels of governance. As a country, we remain deeply committed to the principles of sustainable development and climate resilience. This center is also aligned with Kenya's national priorities, including the Climate Change Act, the National Climate Change Action Plan, and the aspirations under our Vision 2030. Ladies and gentlemen, the Global Center on Adaptation will be a hub of adaptation, innovation, public service training, and policy support. It will bring together researchers, practitioners, policymakers, and development actors to design and deliver practical, scalable solutions on matters adaptation. Most importantly, it will help strengthen institutional resilience, particularly at the devolved levels of government through specialized training and also through technical support. Through this collaboration, we aim to place climate adaptation at the heart of public service training, performance management, and leadership development. This will ultimately support institutional re-engineering for climate-responsive governance. As a country, we reaffirm our long-term commitment to supporting this initiative. I remember when I visited the floating office in Rotterdam, and I did make a commitment on the behalf of the people and government of Kenya, and in my very strong belief that we have solutions that we can offer. And though we are suffering the effects of climate change, we do not want to be just victims. We want to be part of crafting solutions and crafting a future that all of us can live in. It is my very strong commitment that the old style of trying to point fingers at who did what, or trying to blame one us against the other, or the rivalry between the North and the South will not give us solutions. It is the partnership that we can forge between the South and the North, between those who are responsible and those who are victims. And that is how we are going to craft a solution. We are going to craft a new future that will be sustainable for all of humanity. It is a place in history where Africa must contribute its resources, its natural, human resources, and its expertise and knowledge and understanding to craft a future, that is not just sustainable, but a future that serves all of humanity. It is the reason why Kenya has taken a front lead in matters climate action and in providing leadership for our continent as we work towards forging a united front and dealing with the challenges that come with matters climate. Just for the record, Kenya is 80% arid and semi-arid. And we understand full well what a drought means. We also know what floods can do. Just 2 years ago, we had the most serious drought in 40 years of Kenya's history. We lost almost 2.5 million heads of livestock. And subsequently, the year after, we had very serious floods that people in this city of Nairobi, close to 30 people lost their lives in those floods. So we know what climate change means because we live through the effects every day. And I agree with Ban Ki-moon that there are world leaders, there are senior policymakers that are yet to come to terms with the realities of climate change. But that doesn't mean that we cannot forge a future together. It is our responsibility, and Ban Ki-moon said he's not a scientist. I am a scientist, and so I can speak to this subject with greater authority. And I want to persuade those who still second-guess the effects of climate change that we are living a reality. Climate change is real. The effects it's having on our climate are real. Floods, we just recently saw floods in the US, devastating floods. In the US, they are on our screens. We are seeing effects of climate change in different parts of the world. And you see, the effects of climate change are democratic. They don't affect any part of the continent more than the other. We share almost equally in the effects of climate change, and therefore we must forge the way forward and the solution for it together, because none of us is safe. And therefore, through this collaboration, we aim to place climate adaptation at the heart of public service, as I said. And as a country, we reaffirm our long-term commitment to supporting this initiative. We shall closely work with the Global Center on Adaptation to align national policies and facilitate interagency collaboration. To our partners, I urge you to embrace the opportunities presented by this center. Let us work together to embed climate resilience into our operational plans, policies, and development frameworks to strengthen climate-smart planning and service delivery. To our development partners and the private sector, your expertise and support remain vital. We invite you to collaborate with the Center in scaling innovation, sharing knowledge, and creating solutions that serve not just Kenya or our continent, but our global audience. I wish to thank all the stakeholders. I know many people worked long hours to be able to put this successful groundbreaking ceremony today. Many staff, they know themselves. Many people worked long hours. I know that very well. Many people worked on Sunday. Others worked on Saturday. I remember making several phone calls. I apologize for disturbing your weekends, but it was necessary because this climate crisis is real. And therefore, the center that we are building here that is going to harness expertise, bring policymakers into this space, bring development actors, is a necessary emergency. If climate action is an emergency, climate adaptation is more than an emergency. And therefore, the setting up of this office that is also going to provide space for our Ministry of Environment at no cost to the government of Kenya is a very welcome development. I remember having a conversation with Patrick, and we agreed that they are going to spend close to 1.7 billion shillings to put up this office, and we are going to share that office so that we can share the benefits and the experiences and the research and knowledge that will be developed in this center with the government of Kenya as we provide leadership on climate action across the continent and beyond. Today, we plant a seed that will grow into a beacon of resilience, innovation, and excellence. Let this center stand as a symbol of Kenya's leadership in climate adaptation and of our collective commitment to a sustainable and secure future for all of us. Thank you very much, and may God bless you.
Makes a crime triable before a court of law. We just need a statement of offense and a penal section, Your Honor. Your Honor, section 2 indicates a terrorist act as an act or threat of action. Not only an act, Your Honor, but a threat of action which involves use of violence against a person, and that is evidence that will be given before this court, Your Honor. We have people that were injured in the process, that the action endangered the life of a person other than the person committing the crimes. That the action has created serious risk to the health and safety of the public or a section of the public, or results in serious damage to property. That is part 1 up to part 4. Then we jump all the way to part 9. Any act that prejudices national security or public safety. We are all here and we've been following up what has been going on, Your Honor. And we can assure this court that people are not safe. You cannot walk. Just yesterday I had counsel saying that they could not access and travel to various parts of the country. That is safety, Your Honor. And part B, which has been properly submitted, that without it there is no terrorism, states that these acts, which are carried out with an aim of intimidating or causing fear amongst members of public or sections of the public, intimidating or compelling the government to refrain from any act, and destabilizing a religious, political, constitutional, economic, social institutions of the country. What does the charge sheet say, Your Honor? The acts resorted to serious damage to government offices, Kikuyu Probation Office, Kikuyu Law Courts, Kikuyu Sub-County Offices, Kikuyu Chief's Office, Your Honor, the charge sheet highlights Kikuyu Probation Office. It highlights Kikuyu Law Courts, Kikuyu Sub-County Offices, Kikuyu Chief's Office, Kikuyu Registrar of Persons Offices, Sub-County Education Office, Sub-County Accountant's Office, Kikuyu Land Registrar's Office, Dagoretti Police Post, Kikuyu Deputy County Commissioner's Office, among other Kenyan government properties. Yona, who committed those acts? Because from the cursory reading of the law, the acts squarely fall on terrorism acts. The question before these courts that will be subject to the trial is whether the 25 individuals that are before you participated in these terrorism acts that we cannot countenance, Your Honor. We cannot accede to as Kenyan citizens. That question cannot be answered without the trial process. Is there anybody among us, the 24 or 25, that is innocent of the charges? Your Honor, there could be. Is there anybody that is guilty of the charges? We are saying, Your Honor, there could be. Because, and this will be addressed by Mr. Kamau, there is a process on the decision to charge guideline and how we apply the same when it comes to charges. Were these people at the scene of crime, the locus in quo? That is a question that will be answered by the evidence that will be presented before this court, Your Honor. The DPP under Article 157(11) is the gatekeeper at the criminal justice system. We cannot allow, as mandated by the Constitution, under Article 157(11), an abuse of the court process. And therefore, we are neutral, an independent office, and we have to facilitate justice and present the evidence that we have against each and every person that is before this court. The responsibility is not communal. Each person will bear personal responsibility for any act that is seen or proven to have been done. In line with that, Your Honor, and in addition to the fact that we have evolution of law and acts since 2012, whereby you do not need to be affiliated to any terrorist group for you to commit terrorist act. A case in point, Your Honor, are the lone wolves. The lone wolves radicalize themselves online and mobilize people to violence without a clear group affiliation or guidance. Do we have a lone wolf before this court? That is an answer that we can only get after the court looks at the evidence that is before court. I cede a few minutes here to Mr. Kamau, then Mr. Kamau to Ms. Wangui. Thank you.
Your Honor, the question before court, good morning, Your Honor. Good morning. And everyone else in the court. Good morning. Your Honor, I know this is a very serious court that deals with terrorism and counter-terrorism issues and transnational organized crimes. I don't know why people are so tense. The question before court is not very hard, Your Honor. The question before court is whether the DPP, in exercising its decision to charge, did it within the law and the limits of the law. Your Honor, Section 2 and the provision that has been highlighted by counsel, it also has a counter provision. And the counter provision is that, first of all, that provision limited persons being prosecuted for terrorism if acts were done during protests and demonstrations. However, the provision continues to say, if these acts shall use violence against persons, if these acts shall endanger human life and the safety of the public, if they create great risk to the health and the safety of the public, and also result to damage of property, they shall squarely fall within the meaning of a terrorist act. Your Honor, the charge sheet before you on the particulars clearly demonstrates that there was damage to property, serious damage to property, as has been highlighted by counsel area. Your Honor, the Parliament, Article 37, to reign terror and to commit acts of terrorism when there is a scenario of demonstration. And no, Your Honor,
he was inviting the court to take judicial notice.
Yeah, Your Honor. That is what he said. That is my point. Yes. I was calling to court to take judicial notice on what is happening, of people taking advantage of protest and demonstration.
Please allow me to be direct. I think the state was very silent and allowed you. And I think there is room at the point of making rejoinder to point out any issue that you may think that the court should.
Yes, Your Honor. And you know, this is where the heart of all this is falling, and that's why you can see the reactions. We are trying to show the court that indeed these are terrorist acts because they were done judiciary test. This guideline was given to a prosecutor. That when a prosecutor, it can be checked. But how can we check it? We can only check whether DPP exercised this right. And this right is not for me. My colleague will proceed from there.
Your Honor, I would not want to. There was endangering of human lives, and these are all articulated under the Prevention of Terrorism Act, are clear and are proper, and have been made under our mandate. Come later, we will be able to present whatever we have so that we are able to support this count. Therefore, Your Honor, we submit that the charge be.
And Your Honor, with a bit of hindsight, and I'm quite sure, Your Honor, that no Kenyan will look at these young people and call them terrorists of the act. And, Your Honor, as a terrorist, is on conviction to imprisonment for a term not exceeding 30 years, Your Honor. And this is a person who is notice of the situation in the country where it is already publicly pronounced that over 500 others are charging these Kenyans and others with terrorism, the offense of terrorism. serves only the... Everything else flows out of that. We've already dealt with the matter of adequate notice and public notice everywhere. Seen on screen, some of them numberless. Your Honor, I want to advise strongly the Office of the Director of Public Prosecution. Yes.
Senior counsel. Yes.
We here?
Okay, please proceed.
Thank you, Your Honor. This matter is not about advice to the DPP. And I believe that once counsel is acting on our mandate.
Very well.
So counsel should desist and resist.
Well done, Mr. Machira. Your Honor, whatever it is worth, I don't want to respond.
Yes, please.
Objections must be on a point of law.
Yes.
And I have not had any point of law raised.
Indeed.
Your Honor, this is the objection.
Now, yes, please. Can you
the submission by the senior counsel are intended to align
word that is uttered by the other side inflame the the opposite side, and we will feel like
much obliged,
and then we will generate into an exchange of words.
Your Honor, for example, you can be charged, and therefore we invite you to agree with us that the Deputy Chair of Livestream to add what I just said.
I thank you, Senior Counsel, whereas probably the Senior Counsel Bar pertinent to law. Pertinent to law. Your Honor, at this point you will note that on the question of the village case filed was approved, an initial report, it says must. There's a famous, shall any relevant documentary exhibits as a matter of caution and very important, especially on this first count, to confirm the age of the suspects as an administrative body to prosecute cases on behalf of the state. This is a power that the court regulates from time to time. And so with a lot of humility and respect, as my colleagues from the DPP are stating, we urge the court to regulate the conduct and the affairs of the Office of the Director of Public Prosecution. Now, Your Honor, if we may look at a cursory reading of the statement of facts, the persons before you cannot respond if a plea was to be taken. We have watched, as Kenyans, persons wearing the National Police uniform or vandalizing private property in the company of members of the public in Kenya. The tragedy of allowing such a charge to proceed is that even though it may be saved at the end, probably with a discontinuation or termination of the charges, prejudice will have already occurred on the persons before the court. The reading of Section 4 cannot be isolated from the definitive definition of the term terrorist act. And because we have time, limited as it is, Section 2, and I will read it, says, prejudices national security or public safety, and then proceeds to put a rider and says and. So this charge, in the particulars, cannot be left in isolation by saying committed a terrorist act. It has to go with the sub B, which states with an aim. Mental state, what we call mens rea, is very important because the persons before you must respond to either of the three and not all. If they had to respond to all, then in the particulars of the offense, it will have captured it that way. But, yes, that the persons before you, that the statement, the particulars of the offense cannot be read in isolation without the mental state, the mens rea, intended to do what? So that it says and, which is carried out with an aim, so it particularizes them in three. One is to intimidate or cause fear amongst members of the public. If I am too fast, Your Honor, it will ask me to slow down. Yes. Number two, intimidating or compelling the government or international organizations to do or refrain from any act. And lastly, destabilizing religious, political, constitutional, economic, or social institutions.
This is the mens rea.
Yes, yes. So that as they are responding, if they will, the court will find that they should respond. They need to respond to a charge which is holistic. It is inclusive of what they intended to do. Now, finally, what the statement of facts states, and if the court will be minded to also look at the other count 2 and count 3, they are extremely identical to count number 1, with the exclusion of the term committed a terrorist act. Now, if the court would be minded to entertain all 3 counts, what the persons before the court will be doing would be to suffer not even double jeopardy, there's something like that. A criminal law lecturer will have to revise his manual, will be triple jeopardy. Because what it says generally is that property was damaged allegedly by the persons before you. Of great importance as I sit down, and this has not been addressed, it cannot be possible to commit acts under Porter when Article 37 exists, and the court will take judicial notice that in the charge sheet falls squarely on a date that Article 37 was applicable. And that being the case, the drafters of Porter would have stopped Section 2B are not included the proviso that, I will read it for the court as it retires, provided that an act which disrupts any services and is committed in the pursuance of a protest. In fact, Porter does not use the description of the. It foresees that such protest may not be peaceful. So that, as we have seen, allegedly there was property that was destroyed or damaged, and it continues to say, demonstration or stoppage of work shall be deemed not to be a terrorist act within the meaning of the definition, so long as the act is not intended to result in any harm referred to in A1 to 4, which is the present case. On that date, materially, the court should take judicial notice that there was a countrywide demonstration pursuant to Article 37. As the court is winding up and retiring, Your Honor, we all come from different backgrounds and we all have things we do in life. I was once told by my grandmother that even a mortician has rights. For instance, those who work in mortuaries or places or funeral homes may picket and demonstrate when their workload goes down. What I mean is that when the mortality rate of Kenyans go down, Kenyans are not dying, morticians may complain. The work of the Director of Public Prosecution is not an easy one. It is akin to that of a mortician. And there are our colleagues on that side, and the changes. At one time in this country, any person who was urged will not talk much about it because we are being led by senior counsel, and he's my friend. It was meant to be a joke, but everyone is serious. Today, the persons before this court, the persons who are intended to be charged, but tomorrow, they may be our heroes. I urge this court as it retires with the utmost humility, because now, unlike the EPP, I mean it, count number 1, because we will come to discuss the other counts. As I had said on the question of jurisdiction, it is our position that on the second count and the third count, jurisdiction to deal with this matter under the CPC as Section 71. So these alleged offences were not committed within the precincts. Other courts which can deal. I know the DPP is itching to say that the Kikuyu court is not functioning. But there is another court nearby which can handle.
Referred to by Mr. Mwangi. Mr. Mwangi wants to convince you that there are two parts of that proviso that can occasion deemed not be terrorists act within the meaning of the definition of the referred to in paragraph A, Roman 1 and Roman 4. Roman 4 is what is of our interest. He tells you that this should be the act of protest, demonstration, or stoppage of work. That is the act which the proviso is not to the burning, destruction, or anything. It's to the action that has originated. Why am I on the street? To demonstrate. I urge you to rely on the golden rule of statute interpretation. It will not lead you to arriving to the absurdity and the mischief being actuated and perpetrated by the ODPP. The golden rule when it's used for interpretation, would lead you to arriving at a decision that when such an interpretation would lead to unreasonable or nonsensical results to which the DPP is inviting you to. I rest my case.
Yes, Your Honor. See for the strong words by counsel, especially Devon here about nonsensical stuff. I want to respond to that because I know that decision to charge is a very solemn decision. And a lot of repercussions. And we have taken the decision bearing in mind the response. And especially also bearing in mind the current circumstances that we are all as Kenyans are undergoing. And before I sit down, I just wish to say that there is a lot of misunderstanding on the import of the exemption.
Coming from?
Just give him an opportunity to respond to any.
I don't think he has audience, Your Honor, with due respect, and we wish to object to that because we are now reopening the case. Fortunately, that is the rule, and the court must be bound by those rules. We can't make our own rules.
I understand.
Yes.
Yes,
I also as much. Also, on the to limit as much. And when Mr. Mashira rose on his feet, I said to him, reserve anything that you want to say, and I'm not opening up for the prosecution to make any new submission.
No, yes.
And to leave it there.
I am well guided. Okay. But I still insist that unless the court wants to make its own rules that governs proceedings, that this gentleman, the DPP, has no audience before you. And I would wish you to make a ruling on that, Your Honor. I make an application that will make a ruling on that.
Your Honor, with tremendous respect, the Law Society is here and we represent Mr. Ndego. We are asking.
Yes, Your Honor.
Yes, and thank you. Thank you to reopen any new issues.
Yes, thank you. Thank you to the Deputy President of the LSK.
Yes. Your Honor, until when shall we be integrated by the
as long as you remain
Just to save time, the Deputy President LSK went into the realm of new matters. And therefore, once you go to the realm of new matters, it gives a remit to the DPP to address. But I'm not going to address anyway.
Yes.
Just a sentiment. The DPP, and that is what I was saying before I was told to say, each other with a lot of professional courtesy. This is not between us, it's not between you. The matter only affects these people that are before this court.
So I do not think that needs any response.
It doesn't need. I do not be allowed. Or only that you're not. No.
In regard to Ms. Tiga and Peter, of course we'll be making the same application.
Yes.
If we can simply proceed with those two.
Indeed, I think even for the time.
Yes.
And in those two will mostly be adopted.
Good. So, the state is in agreement?
We are in agreement.
Call out the names of so for the accused persons in E068 of 2025, you may be seated. Wale ambao wameitwa kwa kesi ya Daniel kwenye Israeli wanaweza kutafuta mahali hapo kazini. For those that are remaining, please call it out.
Criminal number 70, 2025, State versus Peter Kinyanjui, alias Sarah Wanjiko.
Yes.
They should be here.
Peter
and Sarah.
Please call them. Please call them. Please, let me have the file.
Six constitutional questions.
This is a fresh matter.
This is a fresh matter.
And we are taking quorum on this one as well.
Thank you.
So, Mr. Njiro is the new councillor that is coming into the work, and Mr. Nguringa. Yes.
Yes, there's an element of serious persecution. The officials of the DCP, Democratic, is a party in coalition with several others, including those represented by County Honorable Gachagua, Gabi. That we are seeing state high-handedness. Whenever they hear the name regarding Gachagua. I'm going to invite Council Kibe Mungai to highlight the circumstances. The state feels is not towing their kind of political line, is haunted and charged with terrorism. And I therefore want to invite Wakili Kibe, because these two were even admitted as if they were Al-Qaeda criminals or Al-Shabaab, and wanted to prison.
All the submissions that have been made by my learned colleagues so what we shall be submitting on is try to make some. Your Honor, apart from the taking off from of the charges that are before this court, number one, in Kiambu, miscellaneous criminal application. One of the Sarah Wanjiko Vega was the second respondent. The Honorable Mr. Honorable Gevi Kibiru, the Chief Magistrate of Kiambu, mention of Ms. Wanjiko Vega. Had made a similar application. That case in Roiro is criminal, miscellaneous criminal case number E465 of 2025. We shall make arrangements to furnish this court and the prosecution, if they do not have already, the said two rulings. In those two rulings, Your Honor, the summary is the offenses, particularly the particulars of the offenses facing those two accused persons are exactly the offenses that has precipitated their arraignment before this court. There are in both those two rulings your honorable learned colleagues, the chief magistrates, ruled that the prosecution had not tendered the required evidence or grounds to justify their further detention. Your Honor, those two rulings under the jurisdictions of our country are appealable to the High Court by law at the instance of the prosecution. But Your Honor, the prosecution, because it is part of the executive under the Constitution, they appear under the executive chapter, only that it is supposed to be independent. They chose, instead of complying with the orders made by your honorable colleagues, they decided to deploy the anti-terrorism officers, ATPU, to invade the hallowed precincts of the court, and for practical purposes, abduct those two accused persons for purposes of the current arraignment that is before you. Your Honor, it is unfortunate that yesterday we were unable to access our office, but since Friday, after they were abducted at Ruto and Kiambu Law Courts, I had an intention to bring an important authority from the House of Lords, known as Bennett versus Horseferry Roads Magistrate, a decision from England. Bennett versus Horseferry Roads Magistrate. I can't remember the other citation. But it is one of the most important decisions that could be applicable to what is happening here today. I can't remember the citation. I remember the name of the case. Bennett, B-E-N-N-E-T, versus Horseferry Roads Magistrates Court. Chief Magistrates Courts like you. We shall furnish that decision as soon as we are able. Your Honor, in that decision, the basic issue was this, that Bennett had been, was somewhere in South Africa. South Africa and the United Kingdom had extradition arrangement where you could extradite persons to England. You know, but without getting Bennett from South Africa, pursuant to the extradition treaty, they decided to do a basically to get Bennett from South Africa, get him to England, and charge him. Bennett challenged his prosecution on the ground that there could be and there cannot be lawful criminal proceedings pursuant to an unlawful and unconstitutional act. There can be there is absolutely no validity. In the ultimate, the House of Lords allowed the objection, Bennett. One of the best decisions one can read, and basically saying that, my senior counsel can read this.
Yes, indeed, Your Honor. It's Bennett versus Horse Ferry. Horse as in horse. Okay.
You can read the one.
That's very good. Your Honor, some of these passwords are for the fund.
Indeed.
Just
we celebrate technology, Your Honor.
Then it was his horse ferry of magistrates and another. Horse ferry. Horse ferry is like horse and ferry.
Yeah.
Magistrates court is another. There was a 1993 All England reports. At page 138 and 151 House of Lords.
Yes, my Lord. So that, Your Honor, the basic finding by the House of Lords in allowing the motion was that this prosecution had to be prohibited, not because the state had no evidence, and not because the prosecution did not have sufficient to charge Mr. Bennett, but it needed to be stopped. Because once the prosecution and the police in England engaged in unlawful conduct and unlawfully arraigned the accused person and abetting an illegality and the violations of the rights of the accused persons in terms of the protection of law, if such a prosecution were permitted to proceed. Accordingly, Bennett was discharged, not acquitted, in order to give the prosecution a chance. To arraign him to court in accordance with the law. And so that the court's hands are not stained with the blood and the illegalities, like the acts of abduction and violence that was witnessed at Ruto. Your Honor, applied to this particular case, the issue is simple. The accused persons, once an order has been made, and it used to be civilized a long time ago, once an order has been made that a person has been admitted to bail, it must mean at the very minimum that that person must spend a night in their home, in their house. Otherwise, it would mean that the only choice that the magistrates at Roiro and Kiambu had was to agree with the prosecution. And if you disagree with the prosecution, we abduct within the same courts and bring somebody to committee. Is it called Kahawa or committee? This court? Kahawa. You and bring somebody to anti-terrorism court.
But the nature of the confinement, you're right to call it committee.
So that
yes, I'm going to change country.
You will add anything after me. So that, Your Honor, the issue, and it should bother the conscience of this court, because what's the image that the prosecution and the police, anti-terrorism police, are projecting? That those people that we cannot prosecute on a low threshold of law, we take them to Kahawa Law Courts, the anti-terrorism law courts, on the same issues, on the same charges, on the same facts. My Lord, if that were to be the case and were to be permitted, it would mean that the critical gain under the 2010 Constitution in terms of ensuring that the courts are not an executive branch and an extension of the executive arm of government would have come back. The courts in Roiro and Kiambu did act independently. And so the accused person asked me one thing. Why is the state confident that monkey business that is not possible at Roiro and Kiambu is possible before the Kahawa Law Courts? You know, we beseech you to make it very clear by allowing our objections, by saying that Kahawa Law Courts is also part of the Kenyan judiciary and will do its duty to protect the fundamental rights of Kenyans. Your Honor, my learned colleague, Senior Wamalwa, is showing to me the fact that the Judicial Service Commission actually issued a statement to condemn and object to the actions of the state and its officers that has precipitated the appearance of the accused persons before you. So that, Your Honor, from these facts, it is quite evident that the accused persons, they are armed with orders of the court, setting them free until the state has put its house in order with regard to the same facts that are before this court. Two immediate things arise. Number one, the only way to uphold the dignity and the authority of the judiciary and the courts must be by ensuring that once orders have been given, particularly against a specific group, the DPP and the police, those orders must be complied with. before there is full compliance. And it is easy what that compliance. Arising from that, number two, Your Honor, is that there is an obvious contempt of the court. Contempt of the court is not just contempt as committed before the court in Ruto and in Kiambu. Contempt applies. Contempt of court cuts across the entire kit and caboodle of the judiciary. So there is a contempt against this court in presenting these accused persons before you to stand trial over a matter that the prosecution chooses. We shall not go to the High Court. We shall instead take people to Kahawa. You know, I had some objections to arrogance. Arrogance does not come worse than this. That you are required by law to go to the High Court, you choose not to go to the High Court, and you decide we are heading to Kahawa. Why? Because it is an anti-terrorism court. We shall get back to that. It is still a court in Kenya, my lord. Your Honor. Your Honor, the second part of these orders from Kahawa were this. The prosecution was beseeching those courts to complete investigations. That's why they needed their detention. And the rulings were based on the fact that the prosecution failed to produce the evidence as required by the law. Is it 24A? 24A? 6C? 36A. Under 36A of the CPC. That is the legal facts as far as this matter is concerned. This is Friday. You are sought for 21 days to complete investigations over those very same facts. So that, Your Honor, and here I'm speaking about abuse of court process and abuse of power. It is obvious that, and the law is, as we had submitted in Kiambu, that before a person can be lawfully prosecuted and take a plea, there must be a certain threshold of evidence that must be reached. The position in affidavit of the prosecution, that is the subject matter of the ruling of 4th of July, is that we do not have that evidence. And effectively, the courts were basically saying, let them be out. They gave conditions. You can have them every other day, twice a week, to compare. Nevertheless, here, because the prosecution and the state would hear none of that. They don't even have some respect for the High Court. Because the moment those rulings were made, only the High Court could vary that position. That if you wanted, you are dissatisfied with what those magistrates said, you needed to go and convince a judge of the High Court that these are such dangerous people that your learned colleagues at Ruto and Kiambu got it wrong, and we must detain them. That has not happened. And it is the reason why we say the arrest and arraignment constitutes abuse of power. And the charges that they have preferred and want to be registered before this court constitute abuse of court process. This, Your Honor, I beseech you not to permit the prosecution and the Kenyan state to do this. Because it would mean that the Constitution means what the police and the DPP says it means. Your Honor, under our law, the Constitution is written, we know its meaning, and in terms of dispute, it means what the courts have interpreted. If the magistrates in Ruto and Kiambu got it wrong, get another interpretation on the meaning of our laws from the High Court. Anything short of that would turn this country into a police state. And Your Honor, we cannot have so that, Your Honor, to get into those other 5 points, now that you have that background, Your Honor, it is important that we point out that for purposes of Section 4 of the Constitution, Kenya is a constitutional democracy. That is Sections 4.2. And it is a constitutional democracy in which the values and principles referred to in Article 10 applies. One of them is to ensure that there is protection of law and the Bill of Rights. We submit that in a situation where a serious issues arise as to what is the correct conduct for a constitutional democracy, you cannot be able to say you have valid charges. In short, Your Honor, therefore, we are beseeching this court to make a finding that in a constitutional democracy, like it was done in Bennett versus Osfery in England, this kind of state conduct cannot be permitted. Secondly, Your Honor, is the issue of Article 38. Your Honor, the issue of Article 38 is important because that is the rights that were being exercised on the material day, the 25th of June, across the country. And it is important because my learned colleagues had said something about it, just for me to say that in the definition for purposes, I believe, of Section 4, there is a proviso that is made. Yes. Yes, there is a proviso that is made that that is Section 2 actually, that with regard to that where a protest stoppage of work, that there is an attempt that is made by the Anti-Prevention of Terrorism Act to make sure that this law would not apply to certain kind of actions of a political nature. Your Honor, it is our submission that this proviso in Sections 2 of the Prevention of Terrorism Act was meant to ensure that in enforcing, in the implementation of the Prevention of Terrorism Act, the state would not cross the boundary, because actions that are genuinely and undoubtedly of a terroristic nature are punished separately from actions, any inconvenience, any destruction of property that happens in the course of pursuance of a political cause. That was the distinction that was sought to be made. And I believe, as I believe we've had this discussion previously with Senior Counsel Kalonzo Musyoka, the reason was simple. Why Parliament needed this proviso to be included, that we have it in fake democracies, starting with places like Uganda, where citizens engaging in legitimate political actions end up being charged with terrorist actions and in military courts. In this case, the closest they are getting is to come to a court that is supposed to deal with Al-Shabaab and other people dealing with dangerous things. Yona, this proviso is a logical basis for you, and I thank you for saying that you will take judicial notice of certain events, that the event of June 25, unless it can be categorized that throughout the country, that was a terrorist activity waged by Kenyan citizens across Kenya, there would be no basis to say some Kenyans who went to the streets on the same grounds committed terrorism, everybody else did not commit terrorism. The law must be rational. Because the day it ceases to be rational, it becomes impunity. You know, the related point, and which seeks to fortify Article 38, is Article 50 of the Constitution. This Article 50 of the Constitution, the ones that deals with the right to fair trial, issues to do with jurisdictions, a competent court, trial before a competent court. Your Honor, this is absolutely important for a very simple reason. Your Honor, for purposes of the trial, it must be done in an open court. Your Honor, the trial before an open court has got a very simple meaning. That an open court is a court that does not have extra security, that is easily accessible to the wananchi, and that deals with a matter of a civil nature or criminal nature, in the sense that these are law-abiding civilians of Kenya until they are found guilty. Manod, under the Anti-Terrorism Act, the court that deals with terrorist acts in the Republic of Kenya is not a court that is truly speaking an open court. All of us, starting with myself, we were told to park my car about for facilitation, the facilities of an open court that is provided in Kahawa. Because in Kahawa we deal with terrorists. If for a minute it were to be accepted that people who are pursuing a political cause within the meaning of Article 38 of the Constitution will be tried in Kahawa, we shall not only make a mockery of our national security, we shall also end up weaponizing the law made for terrorists to deploy it against those that we think we disagree with politically. And that is where the issue of political persecution comes in. And Your Honor, we urge the court not to go back that road of weaponization of the judiciary against sections of the Kenyan citizens with opinions that inconveniences the government of the day. We've been there before. It was a catastrophic time, and the reason why the 2010 Constitution exists. You know, that point I make it with regard to two last issues that I'm about to make. Sections 42A of the CPC, Sections 42A of the Criminal Procedure Code, these sections, Your Honor, says it talks about the disclosure by the prosecution. 42A1 says, pursuant to Article 52J of the Constitution, the prosecution shall inform the accused person in advance of the evidence that the prosecution intends to rely on and ensure that the accused person has reasonable access to that evidence. 2 is the one that is most important. In the proceedings under the Preventions of Terrorism Act, the Narcotic Drugs and Psychotropic Substances Act, the Preventions of Organized Crimes Act, the Proceeds of Crime and Anti-Money Laundering, and Counter-Trafficking in Persons Act, the prosecution may, with relief of the court, not disclose certain evidence on which it intends to rely until immediately before the hearing. Then the other provision sets out. You know, why is this section important? This section is important for the simple reason that because terrorists are such dangerous people, that we break, it's a CPC, sections 36A. CPC, section 36A. Just sorry, 42A, sorry. We were dealing with 36A, the other side. Yona, what is it about this section? Yona, what this section is based on is because those specified and to national security that despite Article 50 of the Constitution to prosecute the case without availing of the that is an absolutely important issue because one of the most important sectors, you get the materials for your trial. So when you try a terrorist, you use a lower threshold. Used by JSC when people are being invited to be for higher offices. Majority of judges cite this case as being done to the effect, Your Honor, that a good prosecutions on how it starts, not how it ends. We have submitted, this has started on that, oh, we shall sanitize this, we shall give evidence, everybody will be satisfied, let them wait. What is unconstitutional in a demonstrable manner cannot be sanitized, cannot be constitutionalized. I urge the court to accuse person until they are lawfully presented before this court. Your Honor, we are most obliged.
Submissions by Mr. Kibemungai, I will allow 2 minutes.
Your Honor, I want you to address these issues together with the people of Kenya under Article 159(1) of the Constitution. So I want you to read Article 159(2)(e). It obligates you to apply my colleagues have highlighted. Then I take you to Article 20(1), Your Honor. It binds all laws of Kenya, including the Water Act, is bound by the Constitution. State officers, all state organs, and all individuals that law. What is the full import and implication of binding? It means if the Terrorism Act shall 20(1) of the Constitution, and Your Honor, if you look at 19(2), what was the purpose of the Bill of Rights? It is to give full fulfillment of the potential of all individuals in Kenya. So, Your Honor, if we find a situation where people are demonstrating, and then the state actors sending goons to cause damage, you have now to separate who are the goons and who are the genuine demonstrators. Then you can now assign the offenses. But where the state has immersed itself to participate as goons, then it becomes complicated, Your Honor. And that is why we are all bound by Article 10 clause 1, and that is why we are all bound by Article 10 clause 1 and clause 2, the constitutional principles, national principles and values. Transparency, accountability, integrity. What my learned colleague have analyzed previously is that where is the integrity of the process? if these stakeholders cannot respect even the orders of the court? Your Honor, the third issue I want to raise is, in the charge sheet, they have said that it is part of the charge sheet. Your Honor, the judiciary is an independent arm. Now, if in the charge sheet they are saying that a court of law was either destroyed or whatever happened to it, and you represent the judiciary, then you also have to divorce yourself from that aspect to handle this objectively, so that the independence envisaged by Article 160 Clause 1 is independence even from other judicial activities which cannot interfere with this court, with this issue. So, Your Honor, we have a lot of tremendous respect for this court and for the judiciary. And that's why we are submitting that. In view of the context of these charges, Clause 4 of the Constitution, it is violated. And to the extent that they violate Article 2.4 and the other constitutional provisions that we have highlighted, those charges are invalid. I want to argue only one point of fact. I want you to look at that charge sheet, Your Honor. That charge sheet for Sarah Wanjiku Kutiga and the Peter Kinanjui. Look at the stamping, just page 1. Who claiming? It says, Office of the DPP just received the charge sheet. Your Honor, the law has deleted the power to formulate charges. Look at the face value of the charge sheet. Look at it at the top, at the bottom. It says received. Look at that received. The DPP just received. It did not exercise its constitutional powers as contemplated by Article 157, Clause 6b, to formulate the charges or terminate. The DPP is being used like a rubber stamp. The DPP has become mechanical, and yet the DPP should be the driver and the champion of this process. So, Your Honor, look at the left side of that charge sheet. Look at the left side of that charge sheet. It is written PP. Your Honor, just let us interrogate that one. PP. Who is PP? People are known by their names. People are known by their names. So we don't want these jobs. We want people to take responsibility. If a prosecutor is signing a charge sheet, the condition is name and the rank of the prosecutor. On that ground alone, we don't need to be academic. This is not rocket science. On that ground alone of that charge sheet, the face of it, AA and PP, we don't know who AA is. So he cannot be held to account. So that if there is a problem, we can pursue him in civil proceedings to recover damages. So we don't know who AA is, and I know I have tremendous respect for the DPP. Because my wife has worked as a DPP, so I have tremendous respect. So I am saying this from the bottom of my heart, that they need to be accountable. And that's what we are demanding. Yes. Yes. Your Honor, for that, I think I've added some time.
Your Honor, from the law side of Kenya, allow me to start by saying that we need to adopt our submissions, especially the points of law in regards to the propriety of the charges facing the two subjects before the court in totality, so that we save on time. In fact, for the record, the submissions are in reference to E68 of 2025. Yes. Your Honor,
first, please. Our submission is in difference to the files that we just brought before me. I'm adopting this. Your Honor, the persons before you are currently enjoying orders of this court in reference to their liberty. This is a person to miscellaneous criminal application E290 of 2025 in the Chief Magistrate Court at Kiambu. For purposes of record, by the two. One is arson, contrary to section 332 of the Penal Code. The second one is malicious damage to property. Of the Penal Code. The third one is robbery with violence. Nonetheless, Your Honor, this is a court file. I am very sure that the court has judicial notice, so it's a public document. All I am trying to say, in the interest of time, is that the offences that the persons before you had allegedly been brought before the Kiambu court on a miscellaneous to have custody of them were serious offences than the offences that they have allegedly been brought before you for plea taking today. And I am not in any way saying that offences related to water are not serious. But the ones I have cited carry mandatory sentences that are extremely punitive. Your colleagues in Kiambu agreed in those offences with the respondents and afforded them bail terms. I am reading the National Police Service standing orders at chapter 15. This is section 2 on detention of arrested persons. Section 2(2)(d). The import of this section, Your Honor, is to guarantee the enjoyment of the fundamental right to bail and bond of a person by a police officer. What the masked and hooded men and women wearing the Kenyan National Police Service insignia who whisked away the two failed to appreciate on that day is that the law was not on their side. Before arresting such a person, they ought to have made an apprehension report in section 37 of the CPC to yourself or any other magistrate within the definition of the Chief Magistrates Act. To have the person remanded. That was not done. Your Honor, in Law Society of Kenya and 5 others, I am buttressing what Mr. Kibe Mungai was saying. In Law Society of Kenya and 5 others versus Kithinji and 5 others. This is a constitutional petition E. Your elder brother, Justice Momuye, your elder brother, 373 of 2024, person and or on any instrument or vehicle that they use while conducting law. was not an arrest. In all definitions, it was an abduction. The courts of law must continue to function objectively to safeguard at liberty. I will be at a peril. As I wind up, because I also don't want my colleague, Mr. Ndegwanjiru, to say anything, probably to, again, from the Law Society, we advise the Office of the Director of Public Prosecution to reconsider that decision. Your Honor, from the Law Society, we are extremely grateful for your candor. I know you've been seated there for a long time. Some of us have walked out and have walked in. As a final submission, as you conclude to determine this matter, we thank you and we wish for your...
This is a section which seeks to teeter the trial of offences where they have happened. They being officials of a national political party and courtesy of the submission by the counsels for the defense led by Senior Counsel Dr. Kalonzo Musyoka, that may pop out is, could this be forum shopping? Your Honor, there is need for this court to address that. We don't know whether from here you'll be charged in Garissa or Mombasa. So that kind of nomadism need to be discussed. There's another one, Limuru, very near. And my appreciation of a court is not the courtroom. I was practicing when another room was arranged for that. So, Your Honor, I leave it at that.
Your Honor, before counsel rest, maybe you should clarify the case numbers for which the accused person was charged.
I'm giving you the answer that is already on the record.
Most of that. You know, whenever the DPP stands on their feet or adrenal in lashes.
And you are concluding.
So I was at the tail end.
Thank you.
Yesterday, a tear gas canister was thrown in the cell where he was held in. An officer.
Only 1 minute, Your Honor.
Yes, 1
Just
minute.
Where a police officer shot in broad daylight during protest a man named Boniface Kariuki. The circumstances of that shooting and killing were as they were on the 25th of June. That was 30th of May, sorry. But that's during the demonstration for Albert Ojwang. But that officer was not brought before any anti-terrorism court. Yet the circumstances fits and suits the definitions under Section 2 of the Terrorism Act. It tells you there is a double standard in the manner in which the DPP is executing these functions. Finally, in summary, the doctrine of exemption created by Section 2, which our then Senior Counsel, His Excellency Dr. Kalonzo referred to, exempting protests from acts of terrorism, underscores the necessity of distinguishing between peaceful expressions and violent acts, thereby upholding democratic principles and protecting, therefore, would mean that the charge is stinking to the high heavens and that this
We can have a response. Our forum from the Ruto side has increased. We have Mr. Brian Shield. Can we now allow the prosecution to respond?
Thank you, Your Honor. Listening to submissions by the defense. And before proceeding to make submissions, I'd like to highlight, I think, one issue that has become a contest in these matters. Peter Kinyajui in these matters. Peter Kinyajui and Sero Wanjiku before this court are facing under Section 2B, where the law provides an exception under Article 37. That we agree there was a legal protest. That we agree there was a legal protest, Your Honor, that was ongoing. What we do not agree with them is the road transport was not being used, Your Honor, the public transport system, in pursuance of legal protest, Your Honor, and notices had been. The Act, Your Honor, and notices had been. The Act goes on and says, within the meaning of this definition, as long as the Act, now this is the part that the court should look at. In our charge sheet, we are saying that the harm is not intended to resort to any harms referred as to paragraph A1.4. You will see that any act that happens under the same provisions is exempted from a peaceful, protected protest. Now the act of terrorism, in a very plain understanding, for breaking it down to everyone to understand, it only transits to act once you cross the line under Article 37. The Article 37 is protected, and you are acting, and the demonstration started under Article 37. They crossed that line, and their action resorted to paragraph A1 to 4. Then terrorism charges began. Terrorism acts began. And from the word go, counsel for the defense was submitting from the bar. You've been given nothing. Nothing to show that indeed there were abductions.
Your Honor, politely, I think this is something in the public domain that you...
Your Honor, what I was saying before was disrupted by the counsel. An abduction is a legal term that was taken by the defense in support of an allegation that there was an abduction that transpired. When the two on section 37 of the CPC, but allow me to take you back to section 21 so that we can move. You know, section 21 gives the police the power to arrest. And the arrest at touching. Once you are touched, and then it goes up to confinement. You know, from confinement, then it gets to all means necessary. And from necessary, and this depends with the reaction of the person being arrested. The law says that no greater force than necessary may be exercised. So there was an escalation from touch, but there was no all excess force that was used that was necessary, Your Honor, and that is our submission. And if indeed there was, now that becomes subject to trial. The defense or people alleging that more force than necessary were used, then the burden shifts to them to prove that indeed more force used than was necessary. So abduction, we submit, is a legal term that has legal interpretation, and what transpired is not an abduction, but an arrest. They've equally, submitted that there were other charges that were facing the two accused persons before this court. With all due respect to counsel, there are no charges that were before any other court in the Republic of Kenya. What they are quoting to you are miscellaneous applications for custodial orders pending charging before any court of law. And that is why they've not presented any charge sheets before this court, because indeed there was none. If they are candid enough, they would admit that what was there was a miscellaneous application. And after a decision was made, a decision was made to charge with terrorism, and they were therefore now transferred from to try terrorism from any part of this country. And the charges before you, Your Honor, brings the accused person at the scope of this court. Let me go to section 36, Your Honor, of the same CPC. It provides for detention, gives the police the power to detain people arrested without warrants. Section 36 provides for detention of persons arrested without warrant. Immediately after Section 36, you've been told about Section 37, that they are supposed to report their apprehension to a magistrate. You see, the selective reading of the law of the OCS of the police station have, the responsibility to report that apprehension to the nearest court, Your Honor. And on 4th of July 2025, date of the arrest, which was on Friday, past working hours, the Constitution says that this apprehension, and if the 24 hours falls outside the working hours, then they are taken before the court at the end, before the end of the next court sitting day. Hours. On Monday, the 7th of July, they were arraigned before this court, and the court was informed of the arrest and the matter after arraignment. There is no impropriety, illegality, or abduction. Consequently, from the arguments of Section 36, 37, and the Constitution, that having been said, Your Honor, the two individuals before this court, you're told that they are party leaders. We are not here because they are party leaders, Your Honor. We are here because a charge has been approved. And the jurisdiction of terrorism charges can say that they are being proffered before a court that is not sufficiently equipped to give that decision, since the decision, the ODPP decision to charge at a portal. In legal terms, what they are telling you is, can their decision be reviewed judicially? And if that is so, if that is what they're asking you on, the court that is equipped to deal and to check any excesses in terms of whether the decision was appropriate or not is the High Court on judicial review. Therefore, any argument as to whether a plea will be taken or not, Your Honor, whether the charges are appropriate or not, cannot be legally and sufficiently be heard of before this court. And a decision to charge having been made, then the plea, the most appropriate lesson to take is to allow Your Honor the plea to be taken. The remedy at a judicial review does not subsist the plea taking until the trial is completed. Your Honor, there are some few issues that have been raised about kufeni nyote nyinyi nyote such sentiments, Your Honor. And unfortunately, these are sentiments for the defense. We do not know whether they intend to swear any affidavit to that effect, since information from the bar is a legal force of law unless it's submission. That information has to be communicated in a format known as an affidavit, and not through hearsay from the two defense counsel, but by the person who was addressed. And I'm very concerned that counsel can submit as such. If indeed there was a police officer who did that, that is an illegality that we cannot even entertain. Let them follow the right channels so that we split politics from law and law from politics. Finally, as I sit down, legally, Your Honor, there is nothing presented by the defense, whether constitutionally or through submission, that has raised reasonable grounds, Your Honor, to stop plea taking. The issue as to whether these are the appropriate charges or other appropriate charges should be preferred, Your Honor, is not an issue that can bar plea taking. And we wish the court to find that the charges are before this court. These people have been registered appropriately within 24 hours and plea may be taken. I have two colleagues, Your Honor.
Your Honor, just to buttress the point of my senior colleague, and I will submit on the issues in the application that is being made by my senior counsel, Mr. Kibe, on the issues of whether the rights of the arrested persons were infringed when they were being arrested. Your Honor, these issues would have been raised under Article 59 of the Constitution. And so, counsel should be telling you that his clients were denied counsel, or they were not brought before this court within the 24 hours rule as stipulated by the Constitution, or they were denied counsel, or other issues that are outlined in Article 49 of the Constitution. Those are not issues that have been brought before you. And if they were to be brought before you, or as counsel has said that they were abducted and not arrested, this court, then the question should be, can those answers be answered? But can those questions be answered by this court? And I say, interpretation of law, especially with regards to breach of rights, fundamental rights under the Constitution, can only be interpreted by the High Court. You look at Article 165 of the Constitution, sub-article, that is B, it speaks to the jurisdiction of the High Court and says jurisdiction to determine the question whether a right or a fundamental freedom in the Bill of Rights has been denied, violated, infringed, or threatened. This to say, this court has no jurisdiction to entertain the application by counsel to determine a question of infringement of the rights of the arrested persons. And why are we saying so? Because when counsel alleges these matters from the bar, are we allowed to cross-examine him? Because these are issues that he brings from the bar. Can we put him on the dock to cross-examine him? So this question is a question of trial, requires evidence, requires affidavits, requires to ask to be given an opportunity to respond, because now the blame is on the police officers who are allegedly abducted these individuals. Therefore, Your Honor, we are just saying simply, the issues that are before you are very simple, and they have very, very simple answers. That one, already submitted, and our position is, yes, they are properly brought before this court. And on the issues of whether the accused persons are properly presented before you, those are issues that cannot be litigated here. They have a recourse elsewhere. The accused persons are before you, and they are properly presented before you, and we have supplied them with a charge sheet. And Your Honor, you should allow us, this court should allow us to proceed and the accused person take plea.
Your Honor, I wish to adopt the submissions of my senior and my colleague. I believe we have given sufficient grounds as to why we are charging with these counts, with these charges, Your Honor. We also submit that this is the proper, we use the proper channel, this is the proper court to present these charges. We do acknowledge Article 37, and we do respect it, Your Honor. The issue at hand is whether there was a commission of a terrorist act. We wish for the court to look at section 2A(1) to 4 of the Prevention of Terrorism Act, which provides to when a protest, to what actions can lead to a protest being regarded as a commission of a terrorist act. From the particulars, it's quite clear, we've articulated all of them. There was destruction of property and among other issues. We submit that the charges are proper. The elements of the charge have been articulated in the particulars of the offense. We say that you do allow us to proceed in taking, and the issues of evidence can be dealt with later. where we can be able to show that we were able to use the decision to charge guidelines to make these decisions.
Your Honor, before I speak to the defense, I would also wish to raise a concern. As we are proceeding and making legal arguments before this court, one of the defense counsel, Mr. Ndegwanjiru, advocate, in his Twitter handle, @JiroAdvocate, was busy texting our names on social media and generating a debate, and the title, of the said Twitter is weaponization at its best. He proceeds to say that 3 counsel appearing for the state are weaponizing this process. For me, I take that as an incitement, and I do not take it kindly. And this counsel should be reprimanded, Your Honor. And he should be one also. That should he incite public to generate any reaction, then he should be answerable, and the court should, and the court should take notice of that.
Can you just allow the counsel?
Yes.
The counsel to conclude?
And this is a post that was done at 11:12.
May required to respond?
And also amended and reposted again.
Yes, Your Honor, I do not believe that those are issues under the trial. Yes, I did it in exercise of my rights. Counsel stated their names in the glare of the public and the media. And if I am right, Your Honor, I would wish to restate the said names so that the record may read correctly. Yes, I think we are dealing with Ms. Wangoi, Ms. Mashira, and Mr. Kamau as the counsel appealing for the BPP. If I am wrong, Your Honor, then he can correct the record so that I can edit my tweet.
What about weaponization? Just read the entire Twitter.
Yes, it's there. It's not an interpretation. You can bring an affidavit and respond to it appropriately.
Your Honor, from the Law Society, this is maybe an issue that they can deal with internally in the Law Society. Counsel for DPP has alleged severally that you don't have jurisdiction on everything, probably including this. We can deal with it from an MSK level so that we move on. And it's something that can be resolved. I hear you, Counsel. Mr. Kabata. Yes. Now, I do agree that the statements that have been made by counsel have been brought to the court's attention, and Mr. Bashir, you've highlighted them. I think not for the court to take any particular action against Ms. Njuru, but the court to note that that has been done. And that therefore, Mr. Bashir, you have a statement which is a platform, and for what that is worth, you will know how to pursue that.
Most of that.
Just to say that again, that we the court makes a determination of this process. Why don't we allow the process to run its course? Thank you. So that we don't include absolutely.
Yes. Your Honor, I wish to agree with my
learned counsel from the DPP that the term abduction is a legal term that ought to be used in the technical sense that it means, and particularly for purposes of judicial proceedings. Your Honor, articles, no section, Your Honor, under section 250, the word abduction, or the offense of abduction, is, it induces any persons to come from any place, is said to abduct that person. Any person who by force compels, that's the first part, or by deceitful means induces any persons to go from any place, abduct that person. That is section 256. In the circumstances of this case, we are relying on the first part, the use of force, which was witnessed during the so-called rearrest of the accused persons before you. There was force used to get them from the courts and now to present them before this court. Your Honor, we have gone, the definition, I believe my learned friend from the other side, the DP, Mora Kabata, defined to the court how an arrest should be conducted and pursuant to a reasonable apprehension that an offense has been committed. All that is on record. The point that requires emphasis is that the accused persons had been, let's assume it, they had been lawfully arrested. They had been lawfully arrested, but in the course of processing bail, pursuant to court orders, they were grabbed from the registry while processing bail. Clearly, this was done not pursuant to any apprehension, but to defeat the orders that had been made by your learned colleagues. You can say there is nothing technical that can be able to enable any person using common sense and blessed with reasons by the Almighty God to interpret it any other way. That you are grabbed from the court registry to defeat the orders of the court setting them free on board. In the case of Bennett versus the Horseferry Road's magistrates, copyright. The issue was precisely that if you ought to have brought Bennett from South Africa pursuant to an extradition order, and that order was not there, the court actually said we cannot allow people to be tried in English courts. People who have actually been abducted. Actually, the truth of the matter in Bennett's case, the discharge was on the basis that he was abducted. In the context of this case, and the law has always meant the Constitution, the statute, promulgated rules and regulations, and judicial decisions of the court, and judicial orders. There was a judicial order setting them free. Over the same facts, the prosecution, I was waiting for that. The prosecution, I concede, if these two accused persons had committed terrorism act in Canberra, and Garissa, where this terrorism is actually perpetrated, it would have been a different ballgame. But it was the same offenses, the same set of facts. That the courts had said that there is no basis why your rights under Article 49 should be derogated, because that was the issue. Whether the DPP and the police justify the derogation of fundamental rights. Those magistrates say there were no grounds for derogating their rights and to ensure that they were further detained. Accordingly, any attempt to arraign them before you in disobedience of court orders and to defeat the proper administration of justice cannot be countenanced under the principle laid out in Hospital versus Magistrate and in the Gedongori case, because it was the same case, abuse of power. Abuse of power cannot be countenanced, cannot be tolerated. Your Honor, the issue, you are told that there were no charges that were facing them. But you would read all the affidavit. And that is a specific argument that was made both in Kiambu and Ruto, where I was there myself. They said, we are holding these people on the basis of specified offenses. Mr. Maura Kapata had read you. Robbery with violence, arson, all these kinds of things that are being cited today. And the issue for purposes of Article 49 of the Constitution is not the charge sheet, which is a legal document. It is, what are the offenses against this man and woman? The offenses were set out in an affidavit. So when today you are told we have a charge sheet specifying a terrorism act, this is a fiction used to justify disobedience of the law and to justify abuse of power. Because if it is permitted to proceed as such, and that is a bigger question, the courts would effectively have lost control over the persons brought before it for purposes of any prosecution. Your Honor, you are referred to certain provisions of the law. There is this issue that has repeatedly, you've been told, oh, we are seeking judicial review of the decision to charge that has been made by the DPP. There is no doubt that the DPP can make decisions to charge. High Court. It is a personal decision that you must be satisfied that you have jurisdiction. Jurisdiction can be complicated. But if the adversary was not in Europe, where Gachagua was killed, it clearly cannot, you cannot say that you have a valid charge. Let us wait for the DPP and the police to give us evidence. Call it a rearrest. You know, this is a mischief rule. The court, you know, this is a mischief rule. The court must go to the mischief rule. The last 2 points on the Constitution is this, to the mischief rule. The last 2 points on the Constitution is this, about your authority, that clear provisions of law. Article 21 had been cited by my learned colleague Mr. Ondieki, 21 and 4 of the Constitution. Under 21 and 4 of the Constitution deals with the issue of application of the Bill of Rights. 21 says the Bill of Rights apply to all and binds all state organs, and 21 says the Bill of Rights apply to all and binds all state organs and all persons. Your Honor, you are a state officer and you are required to observe it. But more importantly, 20 Sabbatical 4 is very clear. In interpreting the Bill of Rights, a court, a tribunal, or other. And finally, Article 23 of the Constitution. Article 23 of the Constitution, Parliament shall enact legislations to give original jurisdiction in appropriate cases to subordinate courts to hear and determine applications for redress of a denial, violation, or a threat to a fundamental rights in the bill is exercised directly. It doesn't require any law. So you apply that authority as you understand it. So we are perfectly entitled to say very clear, to protect certain people, is that terrorists across the world, not just in Kenya, are persons who are hated, it is much bigger than the prosecution is making out to be. Because to permit this, it would literally allow the 4,000, 5,000 people that we've been told have so far been arrested to be tried as terrorists. Your Honor, Kenya will cease to be a constitution of democracy if such a precedent were to be set. We have made the objections here. I urge that you uphold the constitutions. You are most obliged.
Your Honor, we have to bring this to its useful conclusion. We thank you for your patience. Thank you. Very briefly, in summation, Section 2 of the Prevention of Terrorism Act, number 30, 2022, and the proviso thereof, we've been addressed extensively on this, and exercising their rights under Article 37 cannot be charged under the Prevention of Terrorism Act. The only thing in that proviso is, if that is proven, then citizens are not covered under that proviso. But our submission is, there's no such intention. Therefore, is actually very clear. It is actually unassailable, and we urge you inappropriate. And for the avoidance of doubt, Your Honor, the Judicial Service Commission issued a very clear doubt. By the way, the chairperson of the Judicial Service Commission is the Chief Justice.
Your Honor, perhaps with your permission,
I do not expect that all the time
it's
trying
okay,
to do these
but
things.
that was not an issue that we did a rejoinder in. There was no statement that we went through. So
So this is a new issue that...
it's not a new issue, it's been referred to.
We need your ruling.
It's not a new
Your
issue.
Honor, with your kind permission and with the permission of my learned senior.
Can I be addressed by the two so that we can quickly do
If I can help refresh your memory, Your Honor. I raised the objection.
My memory is quite fresh.
Yes.
No, I'm saying the reading. He's now going to the reading.
No, it's just the same. The substance is not changed. The issue is just for the avoidance of doubt.
No, he's reading, Your Honor. Is it necessary?
The chairperson of the Judicial Service Commission, and we are officers of court, is the Chief Justice herself. And this statement, the rearrest of an accused person within the precinct of the Kahawa Law Courts on Friday, 4th July 2025. The facts indicate that the accused had been released on a mandate of the police to enforce the law and apprehend the suspects. Use of fire and dignity of the judiciary. Courts are sacred spaces of constitutional adjudication. Okaya, CBS, Secretary, Judicial Service Commission. The date of the statement, Your Honor, argument about the impropriety of the rearrest. I personally like to call it simply abduction, and therefore, Your Honor, you historic because if you decide that the two accused persons, they were yet to take a plea because you object to that. In fact, we are calling on Your Honor to discharge them unconditionally, as happened in the case of Rose and Jerry just the other day. So we're going to argue that, the charges have been preferred, the ODPP has done this, and I appeared in court along with Chief Justice Emeritus, because what Rose and Jerry did was just to accept, to give our opinion with regard to public participation matter that the committee in Parliament dealing with finance had put out to the public. And then she was apprehended, actually abducted. Rose and Jerry today is a free citizen. We want to urge you to use the authority of this court so that you will enter the annals of history as one judicial officer who chose to stand for the constitution of this country. And various aspects have been addressed. Article 20 of the Constitution, for example, which binds all state actors to observe the Bill of Rights, International Bill of Rights, which is part of our domestic law now.
It's a quick question, Counsel.
Yes.
If I were to make my decision in order to enter the annals of history,
yes,
would that be making a decision for personal interest?
No, indeed not. Indeed not. You will. I'll guide you on that one. It is simply that you apply your mind to the conversation that has appeared before you, that has been proffered before you, and to be able to apply the law judiciously, because that is what we're asking you to do. But in so doing, you will also be capturing the moment in our country's history. Right now, judicial notice should be taken of the fact that we are a country at a crossroads, and all of us have to do something to save it. We are simply saying we object to the practice of the Director of Public Prosecutions arresting Kenyans, bringing them to this court, and charge them under the Terrorism Act. That is intimidation of a sort that cannot be tolerated. In fact, it is inflaming of the country. Your Honor, I want to say that these two persons, they're actually not necessarily leaders council, but they are officials of the Democracy for Citizens Party. And the very fact that the whole country is witnessing a situation where two young officials of a party are charged with an attempt is being made to charge them under the Terrorism Act. It's actually inflaming the country. You see some of us, Your Honor, appearing before you with great humility. We're sending a message. We're sending a message that somebody has to do something to ensure that this remains a country under the rule of law. This is not going to be a country where political actors, finding that they're losing ground, decide to deal with their opponents. Soon after this, Your Honor, a member of parliament, a sitting member of parliament, I should not be saying this. It's important for you to know so that as we expand that. A member of parliament from Manyata